Ladies and gentlemen, good morning, good afternoon, or good evening. Wherever you are in the world, we appreciate you being with us right now. This is Lovey Life, a DOM podcast. DOM is a digital and bilingual media company specialized in law at the supranational level. So for all news, comments, analyses related to law in Africa and in the rest of the world, go to our website, dom-online.com, and follow us on our social media platforms, the links of which are listed below. This, however, is neither a technical nor a political podcast. To be honest, sometimes it's barely a legal one. The only prerequisite needed is to have an open mind and 30 minutes or so to spare. We sometimes will have guests from everywhere around the world, and we will always be keen to hear your thoughts. We have a fantastic episode for you today, so please stay with us and weigh in while we argue the case, Lovey Life. Before we get into it, I have to come clean. So, as usual, disclaimer. Today's episode is different from what we have done so far. It is, I believe, a fun episode. I had a blast. But it certainly is different. In our previous broadcast, we have used case studies to explain various legal concepts and explore society's reaction to them. This is, to be sure, the basic structure of this series. So far, we have talked about settlement, changes in the law, and the right to work. If you haven't listened to these episodes yet, and you are interested in doing so, they are available for you to download anywhere. But of course, it is not necessary to follow from one episode to the next. Today's program centers around the issue of transgenderism in sports. Again, I know it is a triggering and hot button topic, but what can I say? We are following the news here, people, so that's what this is. Because there is not enough data in terms of legislation and or case law, I thought it would be fun to take you along on a mock. If you're not familiar with it, it is a fictional situation that is given to law students so that they can start to apply their knowledge to quote-unquote real-life situations. As I am not working for clients anymore, it is a bit of a treat for me, I cannot lie. I hope you'll enjoy it as well. Okay, so the facts are as follows. You are a lawyer specializing in international law, but not in any kind of particular industry. A transathlete swimmer of 18, currently ranked number 1 in her state on all events, comes to your office and says to you that she seeks representation because she feels that the new guidelines put in place by the International Federation for Aquatic Sports, in short, FINA, are, quote-unquote, discriminatory, and she would like to challenge them. She has started the transition process, medically and legally, 2 years ago. That's it. Those are your facts. A quick remark at this stage. I use the term discriminatory in air quotes because it is only your client's contention. You, as a lawyer, have absolutely no idea that it is in fact so. Because we're on a time constraint due to the length of the podcast, we will focus in outlining a lawyer's thought process and devising a legal strategy. So, it goes without saying, but number 1, don't believe procedurals and TV shows you watch. Okay? It's fairly logical. The first thing a lawyer does is try to get as much factual information about the client as possible. It is your job as a lawyer to establish a rapport with your client so that he or she feels like you are in his or her corner. Once that has been established, he, and in our fictitious case, she, will open to give you what you need. Another thing, by the way, clients do not know what is relevant. They may think they do, but usually they either focus on something they feel is important, which ultimately will not help their case at all, or omit to mention very crucial points. That is why you need to ask as many questions and get as much information as possible to help you legally qualify facts. In this instance, she is a swimmer that has started transitioning a couple of years ago, therefore, when she was 16. So, you would start at the beginning and ask, what is her transition journey? How did that come about? What has it been like for her prior and during transitioning? When, if at all, was the transition process completed? What type of support, financial, spiritual, emotional, psychological, did she receive? What are the names of her physicians? Would they be prepared to testify on her behalf? Is she, as we speak, on some sort of treatment? Is her family supporting her? How long has she been swimming? Has she ever competed in both categories? If so, what were her results before and after the transition? What role, if any, did swimming play during the transition period? Has she ever made money thanks to swimming? Does she have sponsors or representation? And everything you can think of, and everything that derives from her answers. And you always finish the first meeting with the biggest and most important question of all. Why is she here? What does she want the end result to be? And that answer is extremely different depending on the client. Some want reparation. Some want retribution. And that is not the same thing. Others simply want to make a stand and be heard. Don't ever forget, you represent your client. He or she, but in our case, she, has to sign off on whatever strategy you devise, so you better tailor it to suit her goal. Now, we will not get into articles and statutes, but rather show you how we arrive at a strategy that we can implement. Once she leaves your office, your work starts. Remember that 1, you are billing people by the hour. And 2, hopefully she's not your only client. Get to work. First order of business, you need to pull out the FINA decision she wants to challenge that is applicable since June 20th, 2022, as well as the bylaws of the association, and read them all. Because the issue has been hotly debated and widely reported on in the press, you have a vague idea of what the FINA decision contains. But because you are a diligent lawyer, you need to read it in full. The thing is, you're not only diligent, you're also really busy. So you breathe a sigh of relief when you realize that the policy is in fact a short document, only 24 pages. No one needs 1,000 pages from a walking client. Now, let's turn to the legal part of your reflection. When you practice international law, there are 2 questions you need to address before any substantive issues can be dealt with. It is a step that is not required in any other branches of the law, but that is absolutely crucial in international law because there is a foreign element, either the nationality of a party, the place where the alleged legal incident happened, the place of incorporation for a company, anything really. Whenever there is a foreign element, and we are dealing with individuals, you need to apply private international law and finding the relevant connecting factors to decide, number 1, what is the competent jurisdiction to hear the case, and number 2, what is the applicable law in the matter. Thankfully, both the FINA decision and its bylaws give the same answers for both. Disputes regarding this policy may be filed before the Court of Arbitration for Sports and would be governed by the policy, its operating procedures, FINA's bylaws, and subsidiarily the laws of Switzerland. Once that is clear, you can read the contested decision with a purpose. So, what does it say? That FINA has convened a working group composed of athletes, scientific, and legal experts, and draw from their conclusions to adopt the eligibility criteria to compete in events organized by the association. In a nutshell, FINA is committed to the separation of aquatic sports into men's and women's categories according to sex-based criteria. Plainly, male athletes, including athletes with differences of sexual development, meaning group of conditions where external genital appearance is discordant with internal sex organs, are eligible to compete and establish world records in the men's category regardless of their legal gender, gender identity, or gender expression. Transgender men athletes, meaning female-born individuals who transition to men, can also compete and establish world record in that category. If they are undergoing treatment involving testosterone or other anabolic substances as part of a gender-affirming treatment, they must produce a therapeutic use exemption for that treatment in accordance with the FINA doping control rules. Turning now to the women categories, all female athletes are eligible to compete and set world records in FINA competitions regardless of their legal gender, gender identity, or gender expression. Athletes who have previously used testosterone as part of a previous gender-affirming treatment can compete in women's categories if the testosterone use was less than a year, did not take place during pubertal growth, and development and their testosterone levels are back to pre-treatment normal, with any associated anabolic effects eliminated. Transgender women, meaning male-born individuals who transitioned to women, and athletes with differences of sexual developments, whose legal and/or gender identity is female, are eligible to compete in the women's categories if they can establish that they have not experienced any part of male puberty before the age of 12 or the onset of puberty, whichever came later. Specifically, the testosterone level may not exceed 2.5 nmol per liter. Another significant provision is that the athletes who do not meet the eligible criteria may compete in any open event FINA may develop in the future, but do not yet exist. Now that you know what the policy says exactly, you can move on to devising a strategy. The policy has exclusionary aspects. It, in fact, states so in so many words. You will have to argue the point that this moves beyond exclusion and is, in fact, discriminatory. Going into the elements of the infraction, you will seek to prove, using the standard of balance of probability, that your client is 1. Directly affected by the policy, 2. That said policy is discriminatory, and 3. That the client has suffered a damage as a result of said policy. Let's say a word about each. Number 1. The client is directly affected by the policy. It is, of course, the easiest element to prove. The FINA decision has a whole section about transgender women, which is the case for your client, who are no longer able to compete if they have experienced male puberty in any way before the age of 12 or on the onset of puberty, whichever came later. In your case, your client started transitioning at 16, well into her teenage years, so she is obviously impacted by these new rules. 2, and this is of course the meat and potatoes of the whole affair, is to try and prove discrimination. I won't go into too much details because it would depend, of course, on various elements that I cannot completely make up. Suffice to say that the first count of your argument would be to argue discrimination per se, meaning in itself. You could, for example, argue that the age of 12 is arbitrary, or look into the limits of testosterone levels that have been set in the policy, all of that informed, of course, by experts in the field, etc., etc. The second count you would need to argue is that even if the court does not find the FINA decision to be discriminatory per se, it has discriminatory effects or consequences that are disproportionate with regard to the intended objective, which is promoting and encouraging the advancement of aquatics in all possible aspects in the world, according to the association's bylaws. Third point you will need to prove, finally, that the client has suffered a damage as a result of said policy. It is again fairly easy to argue that because of this policy, your client can no longer participate in competition sanctioned by the FINA, which in turn can lead to a loss of revenue, especially because she was ranked number 1 in her state. All of this is fairly straightforward, isn't it? Now, we go to investigate FINA's bylaws. They clearly specify, as we have stated earlier, that FINA is an international body whose primary function is to promote and encourage the advancement of aquatics in all possible aspects in the world. One of its missions is the staging of competitions, including the FINA World Championships, World Cups, Grand Prix, World Leagues, and World Series and events. It is also responsible for promulgating appropriate rules and regulations for the aquatics, including administering eligibility criteria for its sports and competition. So, at this stage, what you have learned is that if there is a claim to be made, it can be filed against FINA because it is a legal person who has put in place this policy and who has the authority to put in place said policy. We are making progress, people. We are starting to see some light. To be fair, we could call this a day and schedule another appointment with the client, present her our plan of attack, and see if she's going for it. Except for the fact that you are diligent and you happen to love your job. There is a provision on the FINA policy, specifically Section G7, that states, quote, "Athletes may also seek to qualify for and compete in events that are organized and sanctioned by bodies other than FINA. FINA does not seek to limit the development by others of opportunity to participate in different competitions." End of quote. When looking once again at the list of events that are organized by FINA, let me state what they are again. The FINA World Championships, World Cups, Grand Prix, World Leagues, and World Series and events. There's a glaring one that is missing, isn't it? The biggest and most prestigious one, in fact. You have guessed it, the Olympic Games, of course. They happen every 4 years, and the next ones are in 2 years' time in Paris, France. They are organized by the International Olympic Committee. So, you go and look for the International Olympic Committee Charter and any decision that could be of interest for transgender athletes to see if your client could potentially compete at the Olympics. After browsing their virtual library, you find a document titled Framework on Fairness, Inclusion, and non-discrimination on the basis of gender identity and sex variations that was adopted in November 2021. For ease of reference, we will call this the Ioc Framework. And the framework encouraged all international federations to develop eligibility criteria for the women competition category that reflect the specificities of their particular sports, but that include, to the maximum extent possible, athletes who, without regard to their sex or sex-linked traits, identify as women. Plainly, IOC lets every federation fend for itself, which is, to FINA's credit, exactly what they have done with the policy we have been discussing so far. Still, as it stands, your client cannot compete in the Olympics. But, as you very well know, what a trial does is that if it is done correctly, it not only allocates responsibility and damages, it also allocates a burden for the losing party to amend its position. So, you are going to try something. You are going to challenge the Ioc framework, the one we just talked about, and realize that, well, you really can't argue that it is discriminatory per se. But you may make the argument that it has discretionary effects because transgender athletes swimmers are treated differently from other transgender athletes in other sports, which federations have not enacted a similar policy to that of FINA because of the Ioc framework, and may therefore potentially compete in the Olympics. Does it make sense? A quick look at the Ioc Charter informs you that any dispute arising on the occasion of or in connection with the Olympic Games shall be submitted exclusively to the Court of Arbitration for Sports, in accordance with the Code of Sports-Related Arbitration. This is section 61.2. Said code states that both parties may choose the applicable law or subsidiarily use the laws of Switzerland. There you have it, people. You will schedule a meeting with your client and tell her that you think that the best strategy moving forward is to file an application before the Court of Arbitration for Sports against FINA, challenging the 2022 policy for the eligibility criteria to compete in the women's categories, and that you are going to try and prove that the policy is applicable to your client, that it is discriminatory on the first count per se, and alternatively, that it has discriminatory effects that far outweigh its objective, and finally, that your client incurred prejudice because of that policy. The applicable law will most likely be Swiss. However, FINA deals with staging competitions, including the FINA World Championships, World Cups, Grand Prix, World Leagues, and World Series and events. They are not in charge of the Olympic Games. In order to try for the Olympic Games, you will try and challenge the 2021 Ioc framework, which again is a very long shot. You need to clearly say that to your client, because the effect of that framework create a discrimination between the transgender athletes allowed to try and compete at the Olympics in different sports. And that, of course, has caused prejudice to your client. The Court of Arbitration for Sports has jurisdiction to hear the case, and the laws of Switzerland may apply in this case. What do you think? In your opinion, do we have a case? If you were said client, would you go for it? Let me know in the comment section. Also, if you are interested, we can definitely look at this very same set of facts, but from the point of view of the institution, both the Ioc and FINA, and act as their counsel If it's something you would like to do let me know. I would gladly do that. Thank you so much for being with us today. I want to hear what you have to say. Do you have any comments, questions? Does it make sense? Does it not? Leave a comment below the link of the episode on our social media platforms using the hashtag #LovieLife. The transcript of the program will be available on DOM's website in both French and English. If you have enjoyed this episode, please consider sharing, liking it, and subscribing to the show. We have had some great episodes previously, and we would be very grateful if you would consider listening to them. We will be back with our next episode next Wednesday. In the meantime, please stay safe and take care of yourself.